Hi, I'm just going to wait another couple of minutes to let a few more participants join. I'm sure everybody's outside enjoying the sunshine. Just going to wait a couple of minutes. Hi to anyone joining. I was just waiting a couple of minutes to let a few more people arrive. I can see people are still arriving at the moment. Okay, I'm going to kick off now and see if other people join. That's fine. Don't want to keep people waiting. So hi and welcome. I'm Miriam Boston. I'm an associate in the Intellectual Property Technology and Protection team at Field Fisher. So I focus on a wide range of matters, but in particular, I deal with disputes and have a real interest in copyright. This is the last talk in what's comprised this year's Media Crammer. We've done this virtually, and this is the final talk. In true Crammer style, I'm going to be dealing with a high-level overview of the recent developments. I'm going to be focusing on the salient points. I'm going to try to keep this to around 20 to 30 minutes. I can't cover everything in that time, but I've tried to pick topics which I think will be of most interest and relevance to you. If you have any questions as I go along, please enter them in the right-hand side of the screen, and then if we've got time, I'll pick them up at the end. So the topics that I'm going to cover are firstly the balancing act between the interests of rights holders, platform providers and users. Then I'm going to look at the new copyright directive and where we've got to with that. Then I'm going to focus on a particular case from the Court of Appeal that had guidance on the authorship of copyright works. And then I'm going to look at some case law about what constitutes a copyright work and the threshold for that. So firstly, looking at the balancing of the interests of rights holders, platform providers and users. So this is something that comes up in various cases in the CJAU and really is at the heart of a lot of their reasoning. It's also in the recitals to the copyright directive. So in summary, you firstly have the rights holders who want a high level of protection for their works. Then you have platform providers and intermediaries who want to be able to distribute works, but they do need to have support of rights holders and have sufficient content. And then you want to have users who want to be able to access and use materials freely. In most of the cases, the users are not a party to the litigation, so their rights aren't directly advocated, but the judges do still expressly take them into account. This is just a quote from one of the recent cases that characterises some of the tensions and the pros and cons between putting too much obligation on platform providers. Quotes like that come up in various cases. In terms of the legislation that underpins this balancing act, you firstly have the InfoSoc Directive, which Articles 2 and 3 have the exclusive rights for the rights holder, the owner of the work. So that's the right to reproduce the work and the right to communicate the work to the public. In Article 5, there are the exceptions and limitations to those exclusive rights for particular purposes. And separately, there's the Enforcement Directive, which has a right to information about certain categories of people who have a connection with infringing goods and services. And that came up in one of the particular cases that I'm going to cover in a moment. And then also we've got the Charter of Fundamental Freedoms. So that sets out things like the freedom of expression and also the right to property, which does specifically include IP. On the same day in July last year, just before the summer break, the CJAU handed down its decision in 3 cases. These all dealt with this same balancing act and looking at how that impacts the fundamental freedoms. We've dealt with these previously in quite a lot of detail at our IP Crammer in the autumn last year, so I'm not proposing to deal with them in detail. However, as a brief reminder, the key points arising from these cases were, first, the InfoSoc Directive does aim to safeguard the balance between the interests of rights holders and the interests of users. Secondly, however, that mechanism to allow the balance to be struck is contained within the directive itself, i.e. you have Articles 2 and 3, which are the exclusive rights, and then they are balanced by the limitations to those rights in Article 5. And you can't rely on the fundamental freedoms to alter or expand the scope of those exceptions and limitations. Since then, there have been other cases that deal with a similar balancing act. In the recent case from the CJU at the beginning of this month, they were looking at the provision in the Enforcement Directive that I mentioned, where claimants can request an order for information on certain details of people who've been involved in infringing goods and services. And one of those things is the names and addresses of those people. This case related to some films that have been uploaded in their entirety, so the full film had been uploaded to YouTube. And YouTube were then requesting the email address, phone number, and IP address of the users. However, it was held that in the Enforcement Directive, where it covered the provision of addresses, that was only postal addresses. So therefore, YouTube did not have to provide the email address, IP address, or telephone number. The court looked at the Balancing Act and again said that the structure to balance that right was in the Enforcement Directive itself. This seems to be quite a narrow interpretation, and it does look like it's protecting the users more than the rights holders. However, they did say that member states can do more than is in the Enforcement Directive. So, for example, in the UK, you could get a Norwich Pharmacal order and that could cover far more than is set out in the Enforcement Directive. So you could be seeking the IP address. Another case, which also involved YouTube, so looking at platform providers, came out earlier this month, a couple of weeks ago. However, this was just the opinion that came out a couple of weeks ago. We're still waiting for the decision from the CJEU, so we'll see if that follows the opinion. But the opinion in this case said that when the online platform providers are not conducting an act of communication to the public where the user uploads content, and therefore they shouldn't be directly liable. One of the key elements of a communication to the public is who conducted the indispensable intervention. And the Advocate General was of the opinion that that was the user and not the platform provider. Excluded from the scope of communication to the public is the provision of mere facilities. And the Advocate General was of the opinion that what YouTube were doing was just the provision of mere facilities. In addition to this, he said that despite that position, rights holders should still be entitled to an injunction if they could demonstrate that there was infringement. There didn't need to be any particular misconduct by the platform operator. Now, this is quite a controversial opinion, and it's been described as regressive because it would really be stepping back from the cases that have recently come out of the CJU, which are already looking at widening the scope of communication to the public to capture more wrongdoing and to make it a lot easier for rights holders to protect their works. In asking the courts to go in a different direction, this would be really looking to potentially erase over 20 cases, which is quite significant. Therefore, it's not clear if this is actually going to be followed by the courts. So we'll look and see how that goes. In terms of the Balancing Act, if that decision is favoured, then that's really going to protect platform providers, and it might not be enough for rights holders. Also, we need to see how that's going to fit with Article 17 of the Copyright Directive, because in that act, it deals with this sort of position, but in a quite different way. So the next area that I want to talk about is the Copyright Directive and where we've got to with that. Again, I'm not proposing to deal with this in too much detail because we have dealt with it before. It came into force last year, so people should be aware of this now. However, it's not yet being implemented. That's in the process of happening. So member states such as Germany and France, we know, are actively doing that, and it must be implemented by all member states by June next year. Although the UK is still within the transitional period for Brexit, the UK has confirmed that it will not implement the Copyright Directive. Therefore, it's likely to be a lack of harmonisation in the approach, so it will be different dealing with the UK and member states. The UK was originally very supportive of the Copyright Directive. There are a lot of high-profile music artists who supported the reforms. However, the reforms weren't universally welcomed. Therefore, we need to see if the UK is going to adopt similar legislation voluntarily, or if they will keep our current position. The Copyright Directive covers various areas, but I'm just going to focus on part 4 today. The first aspect of part 4 is the press publisher's right. This is a new mandatory right, which essentially means that search engines and news aggregators are required to obtain licenses from EU press publishers if they wish to use more than a link or a short extract from a press publication. A press publication is defined as a collection that's composed mainly of literary works and constitutes an individual item, and it includes news agencies, but does not include scientific or academic publications. This is intended to be a business-to-business right, so it's enforceable against information society service providers. It's not meant to target users. You can't enforce this right against authors and rights holders, but they are entitled to a share of the press publisher's revenues from uses under this right. The next main section is Article 17. The starting point with Article 17 is that online content sharing service providers do perform an act of communication to the public when it gives the public access to a copyright protected work. That means that this is the opposite of the case that I just mentioned, which said that it wasn't an act of communication to the public. Given that under Article 17 it is an act of communication to the public, the provider needs to obtain authorization from the rights holder, for example, by obtaining a license, and will be liable if they don't. However, they will not be liable if they can show that they took best efforts to obtain authorization and best efforts to block uploads of specific works where rights holders have provided relevant information, and that must be in accordance with high industry standards of professional diligence. In addition to that, they must act expeditiously on receipt of notice from rights holders to disable or remove content and make best efforts to prevent their future uploads. This means that there is likely to be some kind of filtering mechanism required. However, the Article 17 does say that it shouldn't be a general monitoring obligation. This article is really a shift in the dynamics and provides a lot stronger protection for rights holders and does put an additional burden on platform providers. There's still lots of questions about the practicalities of this, such as what are going to be best efforts, what are high industry standards, etc. Under the directive, it was specified that there should be stakeholder dialogues. Those took place between October last year and February this year. And the European Commission this week has launched a consultation asking for feedback about what should be set out in the guidance about how Article 17 operates. So if anybody is interested particularly in that, please let us know and we can look with you about how to respond to that. In terms of who's covered by Article 17, the definition covers a provider of an information society service where the main purpose is to store and give the public access to a large amount of copyright protected works or other subject matter, which has been uploaded by its users and is organised and promoted for profit-making purposes. So you've really got to think there about people who operate like YouTube, essentially. That's the sort of organisation that they're trying to capture here. To make clear what they're not capturing by that definition, there are a list in the article itself about what's excluded, such as not-for-profit online encyclopedias, online marketplaces, and cloud service providers. The third main area that I want to cover from the Copyright Directive is some provisions that deal with contracts between authors and performers. So the main thing here is that remuneration should be appropriate and proportionate to the actual or potential economic value of the rights. And there's a provision that says that authors and performers have to receive relevant and comprehensive information about how their works are being exploited, such as the revenue that's generated from them. There's also, crucially, a mechanism where they can claim additional remuneration if what was originally agreed becomes disproportionately low. So if from the information that they receive, they can see that a lot of revenue is being obtained and that was not filtered through to them, then they can look at addressing that. So just to recap, those are a few areas about the Copyright Directive, and that's not going to be enforced in the UK, but it is being implemented in member states. So you do need to be aware of that if dealing internationally. The third main topic that I wish to cover is a case of Kogan and Martin. So this was a recent case in the Court of Appeal that had some guidance on joint authorship of copyright works. So this case concerned the screenplay for the film Florence Foster Jenkins, and Mr. Martin was credited with writing that screenplay. His partner at the time, Miss Kogan, claimed that she worked with Mr. Martin and she had a significant impact in the development of the characters' dialogue and plot. She was involved in a lot of the initial drafts, but she wasn't around, I don't think, at the time that the final version was actually compiled. At first instance in IPEC, they distinguished between primary skills, so such as writing the work, which they said were protectable, and secondary contributions such as ideas on plot and character, which they said was not protectable. The Court of Appeal was really critical of this IPEC judgment. They gave some really helpful guidance that summarised the law on joint authorship, and they also ordered it for a retrial. In terms of the guidance itself, they first said that what's relevant is that there is a common design and a collaboration. So it's more than just a derivative work. So if I create a work and then pass it to somebody else and they create another work, that's a derivative work they're creating. I'm not a joint author of what they've created. However, if we work together on the original piece, then that's a collaboration. The second thing, that it's not relevant who wields the pen. So it's not relevant who actually fixates the thing into a work. So if I said to somebody exactly what a work should be and identified everything to them and they just wrote it down, I could still be one of the joint authors. You also need to look at the contribution being authorial and what is actually protected by copyright. So I'll come on in a moment to the cases that look at what constitutes a copyright work, but in essence, you're looking at the element that's the contributor's own intellectual creation and where they had free and creative choices. For a screenplay such as this, and with dramatic works, you might be looking at who devised aspects such as the characters, plot, and dramatic incidents, because they're going to be the central parts of a screenplay. There's no need for the contributions to be equal, so it can be that people have different shares depending on their different roles. It might be that one person is the final arbiter and they make all the decisions. However, just because somebody is not making that final decision does not mean that they have no role at all. And the final thing, crucially, they said that the treatment of drafts can really affect the analysis. So if you look at a later draft as a derivative work of the earlier draft, then that's one thing. But alternatively, you could say that the final draft is a single work that required the totality of the skill and labour in producing all of the drafts. In summary, this is just a good overview of the law on joint authorship, and we think it's going to make it quite potentially easier for minor joint authors to assert rights in works. The fourth area I'm going to cover today is about what constitutes a copyright work. So there have been some recent key, very high-profile decisions from the CJAU about what constitutes a copyright work. The facts of these cases relate mainly to whether an aspect of a design that was due to a technical consideration could be protected. I'm not proposing to focus on that particular aspect of the cases, but I'm going to look at the wider implications for copyright law in general. The first case was that of COFAMEL. In that case, the CJAU held that the only requirement for copyright protection is qualification as a work, and this requires two cumulative conditions. Firstly, the work must be original, i.e. it must be the author's own intellectual creation, and secondly, that those elements are the expression of such creation. This concept of a work is an autonomous concept of EU law, and it's got to be applied uniformly. This test is the evolution of the CJAU case law since cases like InfoPack, in which it was held that a work is original, where it's the author's own intellectual creation, and if the work is the expression of such a creation. So looking at that two-stage test, the first part is the originality. The CJAU said that it followed from settled case law that to be original, the subject matter must reflect the personality of the author as an expression of their free and creative choices. However, a work is not original if it's being dictated by technical considerations, rules, or other constraints, because that leaves no room for creative freedom. For example, if you look at the Football Data Co case, it was held that given the rules that related to how you create football fixtures, that couldn't be sufficiently original. The second criteria is about the expression of that creation, and that you must have subject matter that is identifiable with sufficient precision and objectivity. So that comes back to the case of Levolo and Hangelo, where it said there was no copyright in the taste of cheese. This requirement should be a uniform fixation requirement across the EU. The reason for this is that authorities and third parties must be able to identify clearly and precisely what the subject matter is being protected. This is essential to have legal certainty. And furthermore, you've got to look at the key theory behind copyright law. We're here to protect the expression rather than an idea. Copyright shouldn't be able to be used to monopolise ideas. However, this expression of the idea does not need to be permanent. Following COFAMEL, there was also a case of Brompton Bicycle. In that case, the CJEU endorsed the two-stage test for copyright protection. They also gave some further guidance about what constitutes a technical consideration in a design. Another key case for us to look at is response clothing. We think this is the first time that the test was applied by the UK courts. This was in January this year. In that case, the judge said that he must interpret the UK law, and in particular the CDPA 1988, in line with the directive and therefore in line with COFML as far as it is possible. The case concerned whether copyright could protect the weave pattern in a fabric. The judge held this firstly couldn't be a graphic work, so he was really focused on whether it was a work of artistic craftsmanship. On the facts, he was looking at the old House of Lords case law, and he said that at the very least he needed to lower the threshold significantly. One of the key requirements previously for works of artistic craftsmanship had been the aesthetic appeal. However, he was lowering the threshold in relation to that requirement. He said that since the work was an expression of the author's personality and free and creative choices, it could pass the test and it could therefore be a work of artistic craftsmanship. Following that case, the key things the key impact here is that first, the test for protection of 3D objects and works of artistic craftsmanship in the UK is now lower. And also beyond that, it has opened the door for future litigants to argue that the closed list system that we have in the UK is incompatible. So those cases could therefore have quite significant impact. First, these cases make it very clear that the test for what constitutes copyright work is the two-stage test in COFML, i.e. the originality and the expression of that originality. This indicates that any additional hurdles in the definition of a work, such as closed lists that we have in the UK with very narrow definitions, are incompatible with EU law. The approach taken by the courts shows that they are lowering the threshold for copyright protection as a result of this. In particular, with the case law on works of artistic craftsmanship, where there was previously a high threshold for aesthetic appeal, which meant that litigants were hardly ever able to satisfy it and just it wasn't worth litigating. With lowering that standard, it's going to be a lot easier for works to come within that. So now thinking about more broadly, what could come within that? What about things like handbags, furniture, etc.? Things that would previously find it quite hard to get protection. Also, looking at functional objects, if they could potentially be protected if there's still free and creative choices. So for example, there was previously the case that involved the Stormtrooper helmet, and that was held that it didn't have the artistic intention or purpose necessary, and therefore it couldn't be protected as either a sculpture or a work of artistic craftsmanship. In the case, they said that it was utilitarian and it was about a characteristic of the character and it wasn't made by an artist's hand. However, if we're looking at that case after COFML, if that helmet was designed with free choices and reflected the personality of the artist who created it, which is very likely that it did, then it could now be a copyright work. Another case that could go differently is the case that concerns the album cover for the Oasis album Be Here Now. That, if you recall, was a collection of objects around a swimming pool. In that case, the court looked at whether it could be protected as a copyright work, and instead they had to rely on breach of confidence. They said that it couldn't be a dramatic work because it was inherently static. It couldn't be a sculpture because it hadn't been carved or modelled. It couldn't be a collage because there was no cutting and sticking. It was very narrow definitions they were looking at. Now, if we're looking at just the two-stage test, something like that could be protected quite easily. Therefore, there's going to be longer protection for functional designs. So some items that were thought to only be protected under the design rights, if they can now have copyright protection, they can be protected for much longer. Beyond the specific categories that I looked at, it's also going to be easier to argue that non-traditional works should fall within the copyright regime, and litigants can be much more creative with their arguments. In particular, if you think about TV format rights, rather than having to show that there's sufficient fixation in a literary work form of elements of the format rights, if the format is particularly original, it is very likely that it's going to satisfy that two-stage test. Now, obviously, in the UK, we've got to look at the impact of Brexit. The UK does have a closed list system, which is now seen to be incompatible. It's unlikely that we're going to find that a kind of an outright finding that the 1988 Act is incompatible due to the results of Brexit. However, the existing CJEU case law that I've just gone through will continue to apply after the end of the transitional period. We therefore will need to see, will the courts revert to following the traditional, narrower UK approach, or are they going to continue with the EU approach? From what we've heard, and there's been a lot of discussion from judges, senior counsel and legal commentators, they do at the very least expect the courts to lower the standards of the existing categories and interpret them in light of COFML. And so they could be used a lot more flexibly in the UK. Either way, it could be that we diverge and are left with a situation where it's much tougher to protect non-traditional copyright works in the UK than it is in the EU. Therefore, this is definitely something to watch out for and see how the courts apply the test, particularly in the UK. So that's a very quick run through of the 4 main areas that I wanted to cover. I'm just going to take a look now and see if anybody has sent any questions through. Okay. It doesn't look like there's too many questions there, but if anyone does have any additional questions about the topics that I've covered today, given that we're running close to time there, if you have any other questions, please do feel free to contact me. Also, I said there's a few things that we need to see how they're going to progress. So we will be updating our snippets blog with any updates on those areas of law. So do subscribe to that if you're not already. Also, we're holding our IP Crammer in October. That will be done virtually again due to COVID. That's October this year. So if you'd like to attend that and you've not already got an invite, then please do contact us and we can make sure you're on the list, and will be sent invites if they're not gone out already. So thank you very much for joining me on this very sunny day. I hope you all get out and manage to enjoy it. Stay safe and healthy and enjoy the summer. Thank you.